Bill be now read a second time. I give the call on continuation to the member for Kooyong.
Thank you, Mr. Speaker. This cost neutrality approach will not reduce adequately the financial uncertainty faced by applicants seeking to bring sexual harassment and sex discrimination matters to court. The mechanism proposed in the bill provides, in effect, equal protection to perpetrators and to victim survivors in circumstances where there is a vast asymmetry of power and economic advantage. The cost neutrality approach may act as a barrier to accessing justice for victim survivors of harassment and discrimination. Taking a cost neutrality approach to a relationship characterised by endemic inequality only serves to entrench that inequality. The amendment I'm proposing to this bill offers an alternative, an equal access approach. Under this proposal, respondents will be precluded from recovering costs against an unsuccessful claimant. Each party will bear their own costs, except where an applicant is successful, i.e. the court has found that the respondent engaged in discriminatory conduct in breach of the Sexual Discrimination Act, in which case the respondent will be liable to pay the applicant's court costs, as they should be. You should not be excused from costs when you have broken the law. People and organisations found to have engaged in sexual discrimination or harassment in breach of the law should have to pay the costs of the applicant. This will act as an incentive to change workplace cultures that permit discriminatory treatment. This proposal will mean that victim survivors in sexual discrimination matters can take meritorious cases to court with the confidence that if their case is unsuccessful, they won't be subject to an adverse cost order. The approach will ensure that victim survivors can continue to secure solicitors and counsel willing to act on a no-win, no-fee basis, as their legal team will be confident of recouping their costs if the case is successful. Corporate respondents will be no worse off under this reform, as they're already able to claim legal costs as tax deductions. Yes, individual respondents would now be potentially liable for their own costs, even if they are successful. But it's worth noting that in the 9 years of Sex Discrimination Act cases in the Federal Court of Australia between 2012 and 2021, most cases were brought against a corporate or government entity. Only 10% of cases, 7 cases in total, were brought against an individual. If this proposed reform was already in place, it would have amounted to no practical change in any cost orders made in favour of successful respondents over the last 9 years. There are domestic and international precedents for use of the equal access model. An equal access model has already been adopted domestically for whistleblowers under the Corporations Act 2001 and the Treasury Laws Amendment Enhancing Whistleblower Protections Act of 2019. That provision requires that where a claimant applies to the court for compensation in result of their detrimental treatment as a result of whistleblowing activities, that claimant must not be ordered to pay the costs of another party unless they've instituted those proceedings vexatiously. It doesn't exclude the respondent's ability or liability to pay the claimant's costs. That remains a matter for the court's discretion. In introducing this change to the usual cost rule, Parliament recognised, and I quote, that legal costs can be prohibitive to any person seeking compensation for damage, and the risk of being ordered to pay the costs of other parties to the proceedings can deter whistleblowers and other victims of victimisation from bringing that matter to court. Legal costs can be prohibitive to any person seeking compensation for damage. For sexual harassment cases, just as much for whistleblowers. South Africa uses this model. The UK has used this model. The US Supreme Court has long held that in relation to employment discrimination claims, successful plaintiffs should be awarded costs and only subjected to adverse costs where their actions were frivolous, unreasonable or without foundation. It gives perfect sense to give those who expose sexually hostile and unsafe workplaces the same legal standing as whistleblowers. They deserve the same protections without constraints on their achievement of just outcomes. The reform I propose will increase access to justice. People who've experienced sexual harassment and sex discrimination will be able to take their cases to court. Discriminatory behaviour will be appropriately penalised. There will be an important flow-on impact on workplace culture. Victim survivors with meritorious claims will have more options to secure legal representation because they'll know that if they're successful in their claim, there is a guarantee that their lawyers' or barristers' costs will be paid by the other party. This model creates more equitable access to the courts by reducing financial barriers for victim survivors from marginalised communities, migrant women, First Nations women, and women from the LGBTQI community. Each of the 7 recommendations being implemented through this bill is important. All of them are long overdue. When combined, they will fundamentally change how safety, acceptance and respect are perceived in our workplaces and who is responsible for ensuring their presence and their value. I urge the government, though, to amend Section 46 of this bill to protect victim survivors, to support their right to representation and to remove the disincentive to pursuing sexual harassment matters in federal courts. I thank the Speaker.